I'm asking you a question. Do you understand the maximum punishments that you face?
I don't accept those charges. I got a treaty right here that says I wasn't doing anything wrong.
That's for later. You apparently want to do this the hard way again. I'm just asking you if you comprehend the maximum penalty that they're charging you.
I comprehend.
Okay. So, do you understand that you have the right to an attorney, either hired of your own choosing or provided at public expense? Do you understand that right?
I comprehend.
Okay. Do you wish to have an attorney represent you, or do you wish to represent yourself?
I'm presenting myself. I'm here by special visitation as opposed to general appearance or lack of subject matter jurisdiction because of 1836 Treaty of Washington, which was further codified in 2017 consent decree, states that my vote is not legally registered, which makes this unlawful investigation fruit of the poisonous tree.
Okay, so you wish to represent yourself in this?
I'm presenting myself.
Okay.
This sovereign citizen walks into court with a treaty in his hand, claiming the case itself should not even exist. But the judge is not letting him skip procedure, not letting him argue jurisdiction early, and not letting him turn the arraignment into his own courtroom lecture. And the moment he says he's presenting himself under special appearance, you can already feel this hearing about to go sideways.
Mr. McLeod, we were here last time and tried to conduct the arraignment, and you ended up being held in contempt, and so we're continuing the arraignment to today's date. So let's try again. All right, so Mr. McLeod, I've got to obey the dictates of the Michigan Supreme Court. They make me go through certain things.
Sure.
You're here without a lawyer, so I need to obey the Supreme Court and establish certain things so that I can make sure that you can represent yourself. So you've got the right to represent yourself or to have an attorney represent you. You can't do both at the same time. So I need to establish which one you're choosing.
All right, guys, this hearing starts as a simple arraignment, but within seconds it turns into a battle over control. The judge is trying to ask basic questions, but the defendant keeps pushing treaty arguments, jurisdiction claims, and special appearance language. And what makes this so interesting is that the judge doesn't explode right away. He stays calm, explains the rules, and gives him room, but also makes it very clear if this turns disruptive, that self-representation privilege can disappear fast.
So to do that, I have to first advise you of the maximum charges that you face. Count one is a charge of resisting obstructing a conservation officer with habitual second notice. It's a felony punishable by up to 3 years and or $1,000 fine. Count two is operating a motorboat while intoxicated. That's a misdemeanor, punishable by up to 93 days and or $100 to $500 fine and or 45 days of community service, suspending the privilege to operate a vessel, cost of prosecution, or emergency response. Mr. McLeod, do you understand the maximum possible sentences for those charges?
Can I say something for the record?
No. I'm asking you a question. Do you understand the maximum punishments that you face?
I don't accept those charges. I got a treaty right here that says I wasn't doing anything wrong.
That's for later. All right, Mr. McLeod, you apparently want to do this the hard way again.
This is where you can already see the problem. The judge is asking one simple thing. Do you understand the charges? But instead of answering, the defendant pulls out a treaty and tries to argue the whole case right there. And that's the first mistake, because the judge is basically saying that argument may come later, but not right now. This hearing is about procedure first, and the defendant clearly does not want to stay inside that lane.
I'm just asking you if you comprehend the maximum penalty that they're charging you.
I comprehend.
Okay. All right. So, do you understand that you have the right to an attorney, either hired of your own choosing or provided at public expense? Do you understand that right?
I comprehend.
Okay. Do you wish to have an attorney represent you, or do you wish to represent yourself?
I'm presenting myself. I'm here by special visitation as opposed to general appearance or lack of subject matter jurisdiction because of 1836 Treaty of Washington, which was further codified in 2017 consent decree, states that my vote does not need to be registered, which makes this unlawful investigation, fruit of the poisonous tree.
Okay, so you wish to represent yourself in this.
I'm presenting myself.
Okay. And has anybody promised you anything or threatened you in any way to get you to waive your right to an attorney, or are you doing that of your own free choice?
It's not my free choice.
Oh, you mean that you're not choosing to be here because of the charges? I just mean, so nobody's like making you give up your right to an attorney. Well, I said you got the right to an attorney. You don't want to have an attorney. Is that your choice, or is somebody like pressuring you to not have a lawyer?
Who's pressuring you to be here?
That's not what I asked.
Okay. Well,
Is anybody pressuring you to give up your right to have a lawyer?
no.
Okay. See, I'm not.
Now this part is important because the judge is trying to protect the record. He has to make sure this man actually understands he is giving up a lawyer. But every simple question turns into a fight over wording. The judge even tells him, these are not trick questions. And honestly, that line says everything, because the defendant is treating basic court procedure like a trap.
I'm not asking you trick questions. I promise you, Mr. Miller. These are not trick questions. All right. So I'm also required to make sure that you are doing this with open eyes, meaning that you understand the risks of self-representation. So as you found out last time, this court has procedures that this court will follow. And when people refuse to follow them, there will be consequences for them. If you're representing yourself, you're going to be held to those same procedures just like a lawyer would. Do you understand that? Do you comprehend that?
I comprehend that this court does what it wants and violated the due process when they arrested me. So we lost subject matter jurisdiction. This whole thing is a shame.
Do you comprehend that I'm going to hold you to the same standards of procedures that I would to an attorney?
I don't think that's how it should be done. I think there's case law that says that people, when people present themselves, they have different standards.
Well, they don't. I mean, I try to work with them as I am with you. I can promise you I don't have these types of conversations with lawyers at the arraignment because they know what they're doing. So I'm trying to give you a little bit more leeway. But you have to follow the procedures as they are dictated by the Supreme Court and the court rules, and as I say them to be. Not what you think they ought to be, but what I say they are. Do you understand that?
I don't understand. I comprehend it.
Okay.
This is one of the biggest reality checks in the hearing. The defendant thinks representing himself gives him room to challenge everything, but the judge shuts that idea down carefully. He explains that even without a lawyer, you still have to follow court rules. And when the defendant says the court just does what it wants, the tension gets sharper, because now the judge knows this could become another disruptive hearing very quickly.
All right. So let me give you an example of that. About 2 years ago, I had somebody in my court in my other county, similar to your beliefs about the law. And this defendant was raising similar claims as you're seeking to raise here. And they didn't prevail because courts don't agree with those claims. And the person became so disruptive, I withdrew their permission to represent themselves, and I appointed an attorney for that person against their will. The attorney recognized that there was a defense to the charge, filed a motion, and I dismissed the case on the attorney's motion. The person representing themselves would have never recognized or did not recognize that defense. So do you understand, when you represent yourself and give up the right to be represented by a trained attorney, you're taking a risk that there may be defenses that you might miss.
This is actually a strong moment from the judge. He tells him about another defendant with similar beliefs who missed a real legal defense because he was too focused on fake legal arguments. That is the warning. Sometimes a person is so busy trying to prove the court has no power that they miss the one argument that could actually help them. And that makes this moment hit harder, because the judge is not just scolding him, he is warning him.
I comprehend what you're saying.
Okay.
So we can just move forward from the attorney.
All right. So then the final thing that I have to decide is whether your self-representation will disrupt, unduly inconvenience, or burden the court and the administration of the court's business. If I'm judging it just on last time's appearance, I would say, well, yeah, you're going to be disruptive, so I'm not going to let you represent yourself. Today, you've been tempted to go down that road, it seems to me, but you've framed yourself. So I'll at this point find that you representing yourself is not going to unduly disrupt, inconvenience, or burden the court. Understand, Mr. McLeod, that changes. And you decide that you're going to run this courtroom, which you do not. Then I will withdraw your authority to represent yourself, and I'll appoint an attorney to speak for you, and you won't be allowed to speak. But as long as you're going to, follow the proper procedures, at this point, I'll let you represent yourself. All right. So I will find that Mr. McLeod is unequivocally waiving his right to counsel. He's made that right knowingly, intelligently, and voluntarily, and he's aware of the disadvantages of self-representation. And at this point, I'm finding that his self-representation will not be disrupted to the court's business.
This is where the power shifts back to the judge. He allows the defendant to represent himself, but only under one condition: follow procedure. And the warning is very direct. If you become disruptive, the court can appoint an attorney and stop you from speaking for yourself. That completely changes the energy, because now the defendant has permission, but he is also on a very short leash.
Alleges that you did operate a motorboat on the waters of this state while you were under the influence of alcoholic liquor, contrary to Michigan law. That's a misdemeanor punishable by 93 days and or a $100 to $500 fine and or 45 days community service. Court to suspend privilege to operate vessel 1 year to indefinite, and the court can assess the cost of prosecution or emergency response. All right. Mr. McLeod, how do you wish to plead to those charges? You can either plead guilty, not guilty, or you can stand.
I don't plan on pleading because I have a decree right here that says I wasn't violating any laws. Stop it from lawful, which makes everything after approved by the history. So
Well,
that's for evidence. Copy of my tribal card, a copy of the excerpt from the 2000.
Well, that would be like a motion to dismiss later on, which you could file. In fact, you had filed a couple motions to be heard today, and then you withdrew them. If you file motions and want them heard, I will hear them. I'll hear your arguments, and I'll rule on them on the merits and the law and the facts. But you can't skip the entering of a plea and go right to a motion. So I first have to enter a plea, either guilty, not guilty, or you can stand mute and refuse to enter a plea. Am I understanding that you are refusing to enter a plea? It's fine. That's not a violation of court procedure. It's one of your options. You have three options right now: to enter a plea of guilty to the charges, to enter a plea of not guilty to the charges, or to decline to enter a plea to the charges. Which of those three options?
I decline any plea.
Okay, that's fine. That's your right to do so. So Mr. McLeod is standing mute as to the charges. The court will enter a not guilty plea on his behalf.
I checked that, Your Honor.
Well, I'm sure you don't want me to enter a guilty plea, so I have
Well, you can't.
to enter one or the other.
Not guilty plea on behalf of the practicing law for the bench. So are you finding a judicial determination that I'm not guilty?
I do not have to subject myself to your cross-examination, Mr. McLeod. That's not how this works. All right, so I'm going to enter a plea of not guilty on your behalf. Mr. Juliet, are the people requesting a referral to the forensic center?
No, Your Honor.
This part is classic courtroom chaos. The judge gives him three options: guilty, not guilty, or stand mute. But instead of choosing cleanly, the defendant tries to bring up documents again. The judge keeps pulling him back to the actual step they are on. And when he stands mute, the court enters a not guilty plea for him, which is normal, but the defendant still tries to challenge it.
All right. So, Mr. McLeod, I've done everything I need to do today in terms of determining whether you can represent yourself, advising you the charges, entering a plea, and scheduling our next court date. You can feel free to file any motions or objections that you want to have heard to be heard on that date. I can't rule on things orally on that regard. It sounded like today you wanted to tell me some things about a treaty and things like that. You might be right. I don't know. But I'd have to review your written materials. I'd have to review your argument. I'd have to hear from both sides and then make a decision on that. We can do that on the 6th if you file the motion and notice it up to be heard that day. Is there anything further for purposes of arraignment today?
I'd like to have the motions heard earlier than that. And I'd like to be relieved of my bond restriction, honestly.
Well, you filed a motion to review those and then you withdrew your motion.
Because I want to do it separately.
I mean, Well, I guess I could make one exception to that, that the court rule does allow bonds to be reviewed at any time. So I do allow oral motions to review bond. So if you want to talk about your bond conditions right now, I'll certainly do that.
I think they're very restrictive. I think they're a violation of due process. I think that they're unnecessary to prove that I'm going to show up or I'm not danger to the public.
And
This is the simple legal lesson of the whole hearing. The judge is not saying the defendant can never make his argument. He is saying, file it correctly, give both sides a chance to respond, and then I'll rule. That is how court works. But the defendant keeps trying to skip the process and force the judge to deal with his theory immediately.
what those conditions are, because I didn't set them. Those are set by the district court. So let me review here. Which conditions is it that you are thinking are unduly restricted?
They're having you call it anyway, take a drug test.
Is that the only condition you're seeking to have removed?
It's really the only one that, well, not being able to leave the state is kind of silly too. I travel to work.
All right, Mr. Juliet, Mr. McLeod is objecting to the bond conditions of calling the bond line for testing every day and not leaving the state of Michigan. Any response?
If he works out of state, I have no objection to that. We're striking that from the bond condition. As far as the bond line, I mean, this is an alcohol related offense. It has been a while. I mean, there's been no bond violations, so I don't have any objection to the board striking here.
Okay, now the initial conditions downstairs did say except travel for work purposes. Or, I mean, looking at this charge, I've got a misdemeanor charge. I've got a fairly low severity felony charge. So, I mean, if Mr. McLeod, if you didn't show up for court, that would be a problem. But if you wanted to, go to another state for work or frankly for any other reason, I'm not sure why I would care about that.
And this is the twist most people might not expect. After all the tension, the defendant asks to remove some bond restrictions, and the judge actually listens. He reviews the conditions, hears from the prosecutor, and decides the daily testing and travel restriction are not necessary anymore. So this shows something important. The judge was not refusing everything. When the defendant made a proper request in the proper place, the court actually gave him relief.
I don't think this is the kind of case where you would pose a flight risk. So I am going to amend the bond conditions to remove the bond line requirement and remove the restriction on out-of-state travel. If this were a drunk driving charge with a motor vehicle, I don't think I'd remove that because I think I'd still want to have you testing, but I'm really not too worried. You're going to be operating a motorboat right now anyway. So I'll grant that request, Mr. McLeod, and remove those two bond conditions. The court will enter an order so that you don't have to present one to us. Effectuating no further for today, Mr. McLeod. Okay, we'll see you on the 6th. If you do want your motions heard on an earlier date, you can contact the assignment clerk and see if there's a date we can get you in soon. All right, have a good day.
At the end of this hearing, the biggest lesson is simple. The courtroom is not a place where confidence replaces procedure. The defendant walked in trying to challenge jurisdiction, treaties, and the entire case, but the judge kept bringing everything back to the rules. And ironically, the one time the defendant made a proper request, he actually won something. Do you think the judge handled this fairly, or should he have shut down the treaty arguments much earlier? Let me know below, and subscribe for more real courtroom drama.